Hi guys, welcome to the channel. Today I am dictating you 500 words legal dictation at the rate 100 word per minute. So let's get started. 3, 2, 1 and go. Even if the said ground is established by the landlord, he cannot get possession of the building in which construction or structural alterations have been made, diminishing its value and utility unless he establishes that all the heirs of deceased tenant had done so. Clause under bracket D of subsection under bracket 2 of section 20 prescribes another ground for eviction, that if the tenant has, without the consent in writing of the landlord, used it for a purpose other than the purpose for which he was admitted to the tenancy of the building, or has been convicted under any law for the time being in force of an offence of using the building or allowing it to be used for illegal or immoral purposes, the landlord cannot get possession of the building unless he establishes the said ground individually against all the heirs. We are of the view that if it is held that after the death of the original tenant, each of his heirs becomes independent tenant, then as a corollary it has also to be held that after the death of the original tenant, otherwise single tenancy stands split up into several tenancies, and the landlord can get possession of the building only if he establishes one or the other ground mentioned in subsection under bracket 2 of section 20 against each of the heirs of original tenant. One of the well-settled rules of interpretation of statute is that it should be interpreted in a manner which does not lead to an absurd situation. It was rightly said by this court that after the death of the original tenant, subject to any provision to the contrary, the tenancy rights devolved on the heirs of the deceased tenants jointly. The incidents of the tenancy are the same as those enjoyed by the original tenant. It is a single tenancy which devolves on the heirs, and there is no division of the premises or of the rent payable therefore, and the heirs succeed to the tenancy as joint tenant. In Kishore Seth versus Satish Chandra Nigam and others, 2005 under bracket 2 ARC 58, this court also observed, I have considered the rival submissions made on behalf of the parties and gave through all the decisions relied upon by them. It is admitted between the parties that late Ramdas, father of the petitioner, was original tenant, and after his death, petitioner and his two brothers inherited the tenancy and they became joint tenants. It is now well settled that heirs to the original tenant succeed single tenancy, and in such cases there is neither division of the premises in dispute nor the rent payable therefore. The position in this regard is well settled by several decisions of Supreme Court, including decision in Harish Tandon case under bracket Supra and SC Pandey case under bracket Supra. In Chirag Chandra versus Additional District Judge oblique Special Judge under bracket EC Act Jhansi and others 2005 under bracket 3 ARC 437, this court again relied upon the decisions of the Supreme Court in Harish Tandon under bracket Supra and observed that orders passed against a joint tenant is binding upon the other joint tenants. Full stop and over. Thanks for watching the video. गाइस, अगर वीडियो अच्छी लगे तो लाइक, शेयर एंड सब्सक्राइब जरूर कीजिएगा और साथ ही बेल आइकन को प्रेस कर दीजिएगा ताकि आपको डिक्टेशंस टाइम पर मिल सकें।